If you please, Your Honor.
Yes.
I'm Otieno Willis. I'm joined by Mr. Ian Mutisi and Dr. Owiso for the respondents.
May it please the court. My name is Sonia. I make appearance for the state with my colleague Mutisi. You know, the application before you is one dated 12th of August this year. The motion is moved through Article 49 of the Constitution, Section 36 of the Criminal Procedure Code. The application seeks orders for detention for the accused persons on the grounds that the investigation are in possession of explosive contrary which have been alleged by the investigation are in possession by the suspects contrary to Section 6 of Cap 150.
What are the investigations on what?
Pardon you?
Investigations on what now?
They are to carry ballistic forensic investigations in regard to those explosives. They are to carry out investigations on the four suspects regarding the grenades, how they are connected with the suspects. There's an affidavit which has been sworn by the IO, Mr. IP George Karanja. The respondents who are before us. Pardon me?
What's the name of the IO?
The name of the IO is George Karanja, Inspector George Karanja. So according to the investigation, it is believed that the respondents were in possession of 4 explosive hand grenades and they need to establish and have a report in regard how they came to be those explosives, which is contrary to Section 6 of the Cap 15. You know, the respondents were arrested on the 9th of August. And it is in the interest of justice, as alleged in the affidavit, or as documented in the affidavit, they need to cover the following in their report. Subject the suspected hand grenades to the bomb disposal experts for analysis. Subject the communication gadget to the Communication Authority of Kenya. The respondents are also supposed to be interrogated by a multi-agencies on the motive of the explosive due to the security danger they pose. You know, we invite the court to take judicial notice of a similar matter similar matter, miscellaneous application number E2757 of 2024. E2757 of 2024, where two suspects who are among the ones before the court were arraigned in court on the 9th, that is on Friday, and there was a ruling today in regard to the same. And the court noted that the grounds. This application before you also has similar circumstances since the suspects were together. That miscellaneous application, the court gave custodial orders. Then in this particular one, since they've been arraigned on a different day, we pray for 10 days for the investigation to complete and prepare a report in regard to the same.
Your Honor, we open that application. And just to start by setting the record straight, the respondents who were arrested in Dandora, Soweto, not anywhere near Mudaiga number 44. They were arrested in their homes. To Your Honor, there is no compelling reason that has been disclosed for the detention of the respondents. No compelling reason. I'll come back to that, Your Honor, but let me just say again, there is even no holding charge that the state has. You don't have a holding charge. And we relied on a High Court decision by your brother Justice Kimaro, where the High Court had said, where there is no holding charge, this kind of application should not be entertained by the court. In case number 308, criminal case number 3, miscellaneous application number 308 of 2018, it's the case of Henry Rotich versus the Republic. High Court. Michael Rotich, sorry, not Henry. Michael Rotich. Michael Rotich versus Republic. Where there is no holding charge, there should be no basis even to entertain the application. The fourth point, Your Honor, that I want to raise is that the respondents have been interrogated, their statements have been taken, so there is no further reason why you need to be detained. And if it relates to the purported subjecting the alleged evidence to ballistics examination or to examination by CAK, that has nothing to do with them. They have no access to any of the premises where that can take place, or the writing of that report. Nothing stops the state from doing that. The fifth point, Your Honor, I want to inform this court that The state is trying to use this court to sanitize an illegality that they have committed against these respondents. They arrested them on the 8th, 8th of August. And they got to confirm when they were arrested in Soweto. No explanation is being told to you, Your Honor, why they were not even brought before you on the 9th. The law is very clear. Bring a suspect to court within 24 hours of arrest. They have now been detained from Thursday, Friday, Saturday, Sunday, Monday. 5 days. And in those 5 days, they've done everything they would have desired to do to them, including recording their statements and taking their fingerprints. But if they so desire to have them again, summons will suffice. And the court can even tell them to report to the investigating officer on a date specified. No need to deny them their liberty. Because all that could be done has been done when they were illegally being detained for 5 days. And now they are inviting the court to regularize that violation of their rights to liberty. I plead with Your Honor to reject that invitation. The sixth point, Your Honor, that I wish to make. All this revolves around a widely circulated information that I invite the court to take judicial notice of an illegal raid into the residence of one Jimmy Wanjigi, where the purported vehicle and the explosives were recovered. But in another case, constitutional petition number E396 of 2024, Jimmy Wanjigi versus IG, DPP, and DCI,
Petition number
E396 of 2024, which has been served on all the rest, on the applicants instead. Mr. Jimmy Wanjigi is laying bare what transpired at his residence, including the planting by the state of the explosives at his residence. I invite the court to take judicial notice of those proceedings as permissible under the Evidence Act. So if it's a question of ownership of the residence, the owner of the residence is in court. And the owner of the court is giving answers in his petition, which is inviting the state to rebut. So this gentleman has nothing to do with the fight. That is a fight between Jimmy Wanjigi and the regime, which is brought himself before these courts to deal with. Let the innocents go. They are not Jimmy Wanjigi. They are not his children. But they are being made.
Actually, no, they are not his children.
As the family lawyer. And these are also my. I know these gentlemen from where they come from. Over yes. But on light note. They have nothing to do with Mudaiga House number 44. They were arrested in Soweto, in Dandora. So the state is trying to force them into what they don't even know about. So that kind of inquiry I invite the court to consider the balance of interest. The fundamental rights of the individuals that is being threatened. And weigh it against the allegations by the state. The primary owner of the residence has come out and has even filed a case before this court. This is my house. These items were planted in my house. And I have evidence is litigating it in court. The state can deal with it in their response to also rebut. So these gentlemen have nothing to do with it. And finally, Your Honor, I wish to indicate that you've been referred to the case that was before your brother, Honorable Choi. And the parties in that case, in the application, were allegedly arrested at number 44. Allegedly. The parties before you were arrested in Soweto, in Dandora, which is not denied. In fact, in the affidavit, paragraph in the notice of motion, paragraph 2, sorry, the motion, at paragraph 3, sorry. That's paragraph 3. They've indicated they arrested them in Soweto, not in Muthaiga. And I also wish to inform you, Your Honor, that when this, in the proceedings that you've been referred to, before just Honorable Choi, we made an application for review in light of new developments, including the filing of E396. And we informed your brother that even at the time when the application was being made and the ruling was delivered, 5 days had lapsed. Because he had given a detention of 7 days. So we told him they already held them for 5 days in that other case. So they can't continue holding them longer than this. Longer than 7 days they got now. Because the ruling ought to have been delivered last week. In the premises, Your Honor, I do plead that you disallow this application. Orders of attendance before the investigating officer, if need be, will suffice. The respondents, since they were detained, have not been given food. The wife of one of them was able to access the police station on Sunday. For the first time, they were given food and water on Sunday. So it is purely torture. And is meant to punish them for a fight they have nothing to do with. If the fight is between Jimmy Wanjigi and the regime, Jimmy Wanjigi has already said, bring it on, and is in court waiting for them, in his own name. Allow the innocents to get out of that fight, Your Honor, and don't allow the state to continue punishing the innocents. In a fight that they have nothing to do with. I'll allow my colleagues. I've also been joined by Mr. Nati, who is now Court, maybe you can put him on record.
Thank you, Your Honor. Yeah, just to add to what my learned senior has said.
This is
Dr. Wiso.
Dr. Wiso.
Yes.
Oh.
Wiso. Same name twice. The prosecution has referred to 4 explosive devices, which they're yet to determine are actually explosive devices, and 1 communication gadget, I'm guessing that would be a mobile phone. And they have indicated that they seek these custodial orders in order to give them time to conduct ballistic forensic examination of those items. These items, Your Honor, are already in the possession of the police. They are not in the possession of the respondents. Therefore, there is no reason to hold the respondents while the ballistic examination, the items upon which the ballistic examination is to be undertaken, are already in the possession of the police. Secondly, as my learned senior mentioned, the respondents were arrested in Soweto, in their homes. So the police know where they live. If the police want them, the police know where they live. So a simple summons would suffice. And if those summons are not honored for any reason, and we don't have any reason to believe they wouldn't be, the police know where to find them, because they know their homes. That is where they found the 3 respondents. And lastly, Your Honor, in reference to E2757 that the prosecution mentioned, which my learned senior has informed the court that is already under review, the question, the allegation there was that the respondents in that case had not yet been positively identified. So the question was to hold them pending verification, identification of their identity, which of course is under review and contested. In this case, the 2 respondents have already been sufficiently identified. The police have all the details. That is all I would wish to add, Your Honor. I would hand over to my colleague here to decide.
My Lord, my name is Mutiso. I'd like just to highlight paragraph 11 of the supporting affidavit, which highlights the reasons why the police want to detain the respondents. Critically, my learned friend has already submitted that the police already know where their residence is. I also like to highlight that the alleged grenades, the serial numbers have not been indicated on this particular application. And further, in support on why we oppose this application, I'd like to draw your attention to paragraph 14 of a decision recognized as miscellaneous application number 26 of 2018. And in paragraph 14 of that decision,
That's for my competition.
no, my lord, the particulars of that case is Betty Jemutai versus the Republic 2018.
Yes.
On paragraph 14 of that decision, my lord, the court espoused as follows: I do not find that the police offered good reasons for the continued detention of the arrested person because they used to justify the detention being aspects of the investigation. 1, by taking witness statements, obtaining call data on the applicant's cell phone, and securing forensic report on the cybercrime aspects of the case. All the things that could have been accomplished even with the person being out of custody. I'd like to echo the submissions of my senior and state that that whole aspect of the holding charge is very, very essential. And we want to urge this court to just make that due consideration of that paragraph. That is all, my lord.
My name is yes, and that is my name.
Yes.
There is only one short issue that I wish to raise. Your Honor, when you talk about compelling reasons to hold people further in detention, one of the key issues the prosecution or the IO is supposed to inform this court is how complex the investigation shall be. Most of these gadgets are just simple gadgets, you know, that each and every Kenyan owns. The hand grenade is something that the experts who are in the security team are trained to detect, know, investigate about. So basically, 10 days is so long. These are family members. These are people who have families. They are breadwinners. And the fact they've been detained has been sufficient for the investigating officer to get the information required, or investigate and prove how these gadgets came to them, which I believe, apart from the grenades, the others are not illegal to hold. That's all.
The prosecution or the state is placed before you not to delay justice or to do the alternative, but to dispense justice. Your Honor, the defense is insinuating that we are there just to detain the respondents, but that is not the case. As they were submitting, they forgot to mention an important item that an identification parade has not been conducted with the respondents. That is very important. And investigations are ongoing. The defense cannot control how investigations can be conducted. The only good practice they can give or provide or respond is to allow the investigation to take control of their matter so that a report is submitted to the prosecution so that we place our case before this honorable court. Your Honor, it will have also been good practice in regard to dispensing justice if the defense placed their evidence in regard to the issues they're talking about that we need to take judicial notice about so that we can accurately point them out and determine whether they are true or not. And this is an issue that we also raised, that if at all they could have placed all the evidence they're talking about or inviting this court to take judicial notice of, then we will not be at loggerheads. We'll sit down and look at them and be able to say this is true, this is wrong. But they have not done that. This is a court of evidence, and it acts on evidence, and it makes judgments on evidence. In a brief rejoinder, once again, it is also premature to start reviewing a ruling which has not been delivered. We appreciate that they've mentioned that they've made an application to review. That is enough. We further reiterate that this is a complex investigation which the state also does not want to interfere with the investigation and limit its work. Let the investigation do their job, submit the report, and the court will determine on that. Once again, the other issue that the court also needs to take judicial notice of, or rather notice, is that looking at the affidavit paragraph 5, the respondents should be noted that it has been documented they were fleeing, and that's why two of the defense counsel have mentioned they were arrested at Soweto. So that brings the picture that these people were at flight risk.
I want to object to that line because a new thing, and why I object, we did say that they were arrested in Soweto, their residences. Muthaiga and Soweto, even if we are going to take judicial notice of the distance, it's not less than 20, it's more than 20 kilometers. So you fled and you chased them from Muthaiga to Soweto, 20 kilometers away. I mean, we've said they were arrested in their homes in Soweto. And he's saying they were fleeing.
They were being pursued.
They were being pursued. No. In fact, Your Honor, maybe at that point, because they are saying that we don't have the evidence on affidavit, because we've just been served with this
I'm not
application.
recording because you have no audience.
Yes.
You are objecting only.
Oh, yes, I was just going to suggest to Your Honor that since they are here, and their statements on oath can be taken by this court, on the question of how they were arrested in their own homes, nothing about they were being pursued by the state. There was no pursuit. And they are here, they can confirm that there was never pursuit by this.
You don't go that direction. It's
Yes.
an application.
Okay.
Okay. So are you through?
Your Honor, mine is to describe why they were arrested there. Yes, they were arrested there because it corroborates or it strengthens this point that they were fleeing. Yes, Your Honor.
Okay.
Yeah. That's all, Your Honor.
That's all? Now, Dr. Wilson,
Yes,
you are in the area of law. Which area are you in?
I'm in the area of law.
Law.
Yes, indeed.
Okay. What do you mean by incurium? You can assist me with that.
By that, I probably
When a decision is by incurium, what does it mean?
maybe let me console. I've been ambushed. Indeed, Your Honor, it's I was just collecting my thoughts. The decision that is made without the benefit of the full facts. Yes, of
Or the one that we just been overtaken by another decision.
perhaps.
Perhaps.
Yeah.
Okay. So, Counsel, you talked about Chimtai case.
Yes.
It is totally different from the Rotich case, is it not?
Yes, it is.
Why the Rotich case says there must be a holding charge, Chimtai, Justice Edward Muridi goes along to say
Yes.
3 things happen when an accused or a subject is brought to court.
Yes.
Is it not?
Yes, it is.
So it's the latter one.
Yes.
The Rotich is the earlier one.
It's
So which one do we go with?
It actually supports the Rotich matter because the Rotich matter was actually filed in 2016, and in this particular decision by Lord, they have actually made references to the Rotich matter. I just made a clarification on the reasons, the particulars the police need to give to the court on why a particular suspect need to be detained, and the court was very profound in elaborating those key particulars.
Those are part of what it was holding. Okay.
Yes,
The
yes,
one
yes,
was.
my lord.
But the major one was that they cannot be chased away. They cannot be released because they didn't happen. They were informed of their continued being in custody and they are later released on this home. So 3 things occur in Article 49.
Yes.
So you have just read that which is only favorable, but you have not read the whole of it.
The-
You have not brought out the whole of it. But the major thing that Chimtai were dealing with is whether it's wrong for the suspects to be brought seeking, they were seeking custodial sentence, custodial orders.
And I do support your decision. And in the ending of that particular Chimtai case, the court espoused that the court, which was actually hearing the matter, should go ahead and hear the bail-out application. That was the final conclusion. But
For me,
the orders, this was in paragraph 17.
Yes.
Accordingly, for the reasons set out above, the applicant's request for release on bail pending trial shall be considered in the context of the court file in KBT, rather they gave the criminal case number, coming up before the court later today. That was the court orders.
All right. The ruling in this matter will be on 15. Take it tomorrow. We should have the ruling.
Your Honor, in light of, because they've already been detained for 5 days, and if you say 15th, Your Honor, that takes us to that Thursday. I was going to plead with you that if you can even make the determination, but reserve your, the full text, so that they've been there already 5 days. And if you take it to 15, the application actually.
I've never seen a lower court giving making rights.
No, you can write the ruling, but it's presented by the Supreme Court that in the exigencies of time, because if you talk of 15th, Your Honor, what will happen is that
14th
by that day we'll have the matter is determined.
Yes.
The 10 days they're asking for, they'll have gotten it anyway. That's what I wanted to raise.
Can we have it on 14th, please? That's okay.
I thought, Your Honor, you'll recommend us for tomorrow. You'll recommend us for tomorrow.
What is so?
Because I'm just worried that
tomorrow, I believe it is agency day.
no, Wednesday is Wednesday actually. It's actually
Are you
Wednesday.
sure they not go to the street?
It's actually Wednesday. It's actually Wednesday, not tomorrow. And Your Honor, why I was saying that, Your Honor, with the, I mean, I'm just saying with you.
Tomorrow?
Much obliged.
Let them stay and tomorrow. Any other matter?
Your Honor, isn't that one?
I have a judgment which
Yes. That's okay. Thank you.